From a man reckless enough to drive at dangerous speeds, causing a loss of life through his carelessness,
operating a motor vehicle, having a moving violation that resulted in death. You understand that charge, sir?
Yes, sir.
to another negotiating probation terms and financial responsibilities.
But I'm thinking I pay at least $96 by the end of the month, and then I want to ask you if I could get on a $200 payment plan a month.
These are 9 moments where Judge Simpson ensures offenders face the consequences of their actions, starting with Mr. Hund, whose reckless speeding didn't just break the law, it shattered a life. This case will leave you questioning if the consequences will ever weigh as heavily on him as they do on the family left behind.
Good morning, Your Honor. Michael Vincent on behalf of Hunter Botterill.
I see my life getting worse. Your name, sir? Seven sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Hunter Botterill.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating a motor vehicle, having a moving violation that resulted in death. You understand that charge, sir?
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on there.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not currently.
Okay. Has anybody promised you anything to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yep.
And of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Mm-hmm.
Yes?
Yes.
Yes.
March 4th, 2024, at the location of Packard and Carpenter Road, were you operating a motor vehicle?
Yes.
What happened?
Yeah, board here, Your Honor. Were you driving southbound on Packard approaching Carpenter?
Yes.
Were you going 62
Well,
miles an hour?
Hold on, Mr. Vincent. Packard Road doesn't run north and south.
I'm talking Packard that runs into Carpenter, east and west, excuse me.
Yeah, you said southbound on
Yes.
Packard, Nick. Go ahead.
Were you driving east on Packard Road approaching Carpenter?
Yes.
Gotcha.
At that time, were you driving the speed limit 45 or were you going 62 miles an hour?
62.
At 17 miles over the speed limit.
Yes.
And as a result of you speeding, you crashed into a vehicle
Yes.
and it caused the death of Alawasa, Deshmane. Your crash caused her to die.
Yes.
Counsel, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
January 15th at 9 a.m.
January 15th, 2025, 9 a.m.
While Mr. Hund faced charges for his actions, here's Mr. Davis, standing before the court for flouting probation terms, dodging responsibilities, and piling up new criminal charges.
Good morning, or afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Davis. Please state your name for the record.
Mayor Dwayne Davis.
Thank you.
Teresa Claire on behalf of probation. Your Honor, Mr. Davis is before the court for a violation of probation hearing. Mr. Davis is not compliant with the terms ordered in his probation case in that he owes a balance of $965. He's made no payment towards that fine. He's failed to complete the relapse prevention program, failed to complete mental health assessment and or treatment, failed to complete 25 hours of community service, failed to report to probation as directed. He has 3 new criminal convictions in RMC stolen property under 200. The alleged date of, or I'm sorry, the date of offense for that was April 23rd of 24. He also has a retail fraud out of Van Buren. That date of offense was August 6th of 2024. He has a controlled substance use out of the 34th District Court, date of offense, August 11th of 24. He also has several new pending cases, which he's scheduled for court hearings, minus one out of the Third Circuit Court, and he's on bench warrant status with that. Probation is recommending in this case, Your Honor, that Mr. Davis serve 280 days in jail with 280 that he served, waive remaining terms, accept his financial obligations, and discharge him from probation without.
Your Honor, I did speak with Mr. Davis regarding the recommendation. We do ask that you adopt it. Regarding his Wayne County case, I did email his counsel in that one to see if they can get him arraigned while he's in our jail. He does have a couple, obviously, other pending matters. He'll be before you on Thursday. So again, we ask that you adopt this so Mr. Davis can focus on his other cases.
Davis, anything you want to say?
No, Your Honor. I'm in agreement with my attorney.
Pardon?
I'm in agreement with my attorney.
Okay. Let's see before the last one. All right. Sentence of the court, 280 days in jail, credit 280 served. I'll waive all remaining terms, except his financial obligations, discharge him from probation without improvement.
This time, it's Ms. Anuka, facing charges of child abuse. It's outrageous how some people believe they can neglect and harm vulnerable children without being held accountable.
Good morning. What's your name?
Annika Skib.
Annika. Got it. I said it all wrong. All right, my apologies. All right. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about July 4th, 2024, at the location of 4842 Washington Avenue, apartment A3, Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of child abuse in the 4th degree. You understand the nature of that charge, ma'am?
I believe so.
Yes? Okay. That is a misdemeanor punishable by up to 1 year incarceration or probation up to 5 years. Do you understand that, ma'am?
Yes.
Okay. First question I have for you is, do you want to be represented by an attorney?
I believe so. Yes.
Okay. Well, do you?
Yes.
Okay. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Skib. We waive any further reading, stand mute, and request another pretrial date, Your Honor.
Defendant having waived former reading, standing mute, the court will enter a not guilty plea. Pretrial in this matter will be adjourned January 8, 2025, 9 a.m. As to bond.
In this case, the people are requesting that there be an order entered that the defendant have contact with the child victim as allowed by CPS or any order they might have. And people request alcohol monitoring. The defendant did not submit to a PBT when made when the police and Huron Valley ambulance contact with her. The allegations do include intoxication to the point of not being able to supervise the child.
Any response?
Your Honor, I did just speak with my client. She says that CPS, the case with CPS has been closed. There's no further monitoring. I would ask that the judge just enter not a bench warrant, a personal bond, and advise her not to consume any drugs or alcohol, but not impose any orders at this time for monitoring.
So the CPS, it's closed at this point. And does this involve one minor child or more?
One, Your Honor.
One. And is that child currently with you? No.
Your Honor, we both live with my fiance and his mother, and that was true at the time of this charge as well. So my son and I both live with his grandmother, essentially.
Got it. Okay. But, and I guess maybe I should have made my question more clear. It's not as though once CPS closed it, the child is someplace else. The child is with you, in essence. And, okay. On that representation, I won't order what the people are requesting in terms of the CPS order. I will order standard conditions, including no assault behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
I will order that the defendant no alcohol, recreational marijuana, or any illegal drugs. I'd ask, while the allegations have been made, are there defendant have any other alcohol related offenses of any type?
No, Your Honor.
She represented to me that she has no criminal history. Your Honor.
Oh,
I only see traffic. I don't see anything else.
but the people are representing that alcohol was involved in this event to the point that, at least as the people are alleging, she was unable to properly care for the child due to intoxication.
That is the allegation, Your Honor. The police officers, when they did make contact with the defendant, observed her speech to be slurred, and other indications that she was intoxicated. That woman, she was the only person who was caring for the children.
Okay. Council approach brief.
It's outrageous how some people know it's wrong to steal and still do it. Here's Mr. Strong, a repeat offender who can't seem to stay out of trouble, now facing yet another charge for retail fraud.
Court does call the case People versus Carlos Strong.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Strong, who appears via Zoom from the Macomb County Jail. Sir, could you please state your name for the record?
Carlos Jaquan Strong Jr.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Strong will be pleading no contest to the added count retail fraud in the third degree. And in exchange, the original count 1 of retail fraud in the second degree would be dismissed.
That's correct, Your Honor. He'll be pleading to a 93-day misdemeanor with a $500 fine or treble amount, contrary to MCL 750-356D as in dog 4.
You want to raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again.
Carlos Strong.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud third degree. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Okay. Do you understand what a no contest plea is? So, sir, do you still wish to plead no contest to this charge?
Yes, sir.
All right. And so to the charge of retail fraud third degree, how do you plead?
No contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
I understand.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
On probation for the 24th District Court.
All right. Were you on probation at the time of in June 26, 2022?
Yeah, I got a probation violation. I had sent off a writ. I got a hold in here for the same case. I sent off a writ. I'm waiting on them to respond. They responded once, but I didn't send my proof of incarceration. I just resent my proof of incarceration with another writ out a couple of days ago, so I'm waiting on them to respond while I'm in here. I might go to court for them in here too. It's Allen Park and Melvin. They're the 24th District Court. I've been on probation since 2017 for the same case.
That is correct as to the Wayne County hold, Your Honor.
Okay. So
I got another Wayne County hold. It's for Harper Woods, but them my last 2 holds. I got a retail fraud, or is it shoplifting? I think it's a shoplifting out of Harper Woods. It happened. I believe it happened Earlier this year. It happened earlier this year in February.
Mr. Strong?
Yo,
Okay, so now that we've determined that you're on probation, sir, I have to advise you that your plea in this case could be a violation of that probation. You understand that?
yes,
Okay. And as such, that other court could sentence you to the maximum allowable under that other charge or charges. You understand that?
yes,
And understanding that, you still wish to plead no contest?
yes.
Okay. Has anybody promised you anything other than what's been stated here today to get you to plea?
I'm not sure. I can't remember. I think I'm supposed to be getting tried concurrent. I'm not sure.
Mr. Strong, the judge is asking you if anyone promised you anything outside of what we've said today in court to get you to plead no contest to this charge.
I can't remember specifically. I think you said something about a concurrent plea or deal they was thinking about doing with my time served. No, I don't think so. No.
So nobody promised you anything else?
Not other than what I stated.
And what was that?
I believe.
So nobody promised you anything in regard to this case other than that the charge would be reduced. Is that correct?
And ran concurrent with my time
Concurrent
here.
to what? To what's your time now?
6 months. I'm in here for 6 months. I get out in February 22nd.
I believe Mr. Strong might be referring to the fact that he would have 93 days credit at the time of sentencing in this charge.
Shocked I am.
So I think he is.
So that's what he's referring to.
I believe so.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2022-8001. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant guilty of this offense. Counsel, have I complied with the court?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea of no contest to count two. Count two. Count one is dismissed. So we don't go through this again. Is there any restitution?
To my understanding, sorry, Your Honor.
Go ahead.
To my understanding, there was no restitution issue.
I don't see an issue that there's restitution in this when I read the report. Okay. Any objection to proceeding sentencing from either side?
None from the people.
No, Your Honor.
Thank you. Sir, is there anything you want to say before I impose sentence?
Yes, I would like to apologize to the citizens of Pittsfield Township and to the county, Washington County. I stayed out there for 3 years. I went to Eastern Michigan University. I enjoyed it. I had the time of my life. I was just stealing food to get by both times. I went to court last week for a charge I caught back in 2018 with 1482 District Court. And court in Ypsilanti for a charge, retail for a third degree, for stealing food out there at Eastern Michigan University. I didn't have a job, I didn't have a meal plan. I had a bunch of jobs, but I couldn't keep them. I had about 15 jobs my last year in college, in and out. I'm my own first-time non-violent, non-felon offender. I wasn't trying to cause too much harm, make a business go bankrupt or anything like that. It's at the Myers Strong nowadays, put a lot of stock into it. My side bought a lot of stock on Cash App, but I apologize.
Thank you. It's the sentence of the court, $125 state minimums, 93 days jail, credit 93 served. Thank you, Mr. Strong. You have a happy holiday, sir.
Unlike Mr. Strong's case, here's Mr. Ricky, facing serious charges for endangering lives with his reckless decision to drive under the influence.
Court does call the case People versus Ricky Heft.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Your Honor. Jeff Law on behalf of Ricky F. Mr. F, can you state your name for the record once you reach the podium? Ricky F.
All right, it's just an arraignment. All right,
Yeah, first part, Your Honor, arraignment. Stand mute, ask the court enter a not guilty plea.
defendant having waived formal reading, standing mute, court will enter a not guilty plea. Yes, sir.
And with regard to pretrial, Your Honor, we have reached a resolution on this matter to a no contest plea to impaired driving. I do have an advice of rights, which I went over with my client and he has signed.
All right. I need a report.
If I may approve.
No contest to,
An added count 2 of operating while visibly impaired.
And the reason for the no contest plea, Your Honor, is for lack of memory.
very good. Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Ricky CF.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. Court could order community service and any rehabilitative services the court deems necessary. You understand that?
Yes.
The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Do you understand what a no contest plea is? All right. Two things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. So to that charge, sir, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind. All right. You signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been provided and is reviewing Pittsfield Township Department of Public Safety report for their case number 24-14554. Any objection to the court reviewing that report?
No objection, Your Honor.
No objection.
Check one thing. Where's my? Oh, there's a silver marker button. That's why I don't see it. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule and would be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be January 15th, 2025, 9 a.m. As to bond. Anybody?
Well, Your Honor, you can tell that there was a crash in this case.
Yes.
So I would request that the court impose some type of testing between at least now and the sentence date. Given that there was a controlled substance at that time that has now been declassified as a gabapentin. So I don't know if there could be another, rather than a sober link, perhaps an ETG or what other test is available would be.
Yeah.
Your Honor, this incident occurred August 31st, so it's been almost 6 months. He has quit drinking at that time and has not had anything to drink since. He's been attending AA meetings at least a couple times a week. So he's taking this very seriously and under his own accord, and I think he will continue to do so.
What I will do is I'll set the defendant's bond at a $25,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. So there is to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, sir.
I will order that the defendant report to community corrections for testing. And I think the way that I'll do that, at least between now and sentencing, is 1 time per week ETG.
Okay.
Just so that we can see what's there. Okay.
All right.
Just like Mr. Ricky, here's Ms. Lindman, standing before the court for her reckless decision to drive while intoxicated.
P number 85044, appearing on behalf of Ms. Lindeman, who is next to me.
And your name, ma'am?
Rachel Lindeman.
Thank you. All right, go ahead.
Your Honor, we've received the recommendation of the probation. The only corrections we would have would be under the physical and mental health. And they're just basically some housekeeping type of corrections. She doesn't meet with her psychiatrist quarterly for medication reviews. She reads more often, approximately every 6 weeks. And her therapist is not with Trinity Health. Her therapist is in private practice. Other than that, Your Honor, we would adopt the recommendations of the probation. The only request that we would have is Ms. Lindeman has $200 today to be cash today to be, which she will pay after sentencing towards restitution. But in light of the fact that she is on SSI and only brings in $1,200 a month, we would request that the fines and costs, $480 fines and the $180 probation be waived due to her income.
Okay.
If the court wishes, we will follow through with the ability to pay packet also.
Okay, yeah, and I think that's what you'll do. I'll order what I'll order, and then you can get that packet to us. Ma'am, anything you want to tell me before I impose sentence?
No, sir, none that I can think of.
Okay, all right.
Thank you.
You're welcome. It's a sentence of the court, 6 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $180 probation oversight fees, $225.70 restitution to Walmart payable through the court. And of that, you have 200 today?
Yes.
Is that correct? All right. I'll mark that you're going to pay that today, 200 today toward the restitution. I will indicate that all of the rest of that will be a payment plan as determined by probation or set up through probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You are to continue your individual therapy with proof to probation. No going to any Walmart store in the state of Michigan. I will set a review hearing that's to be held June 11, 2025, 9 a.m. I'll order 93 days in jail. That is suspended.
Thanks.
Judge Simpson is faced with yet another DWI offender. This time, it's Ms. Ulmer, whose reckless choice to drive while impaired has brought her to court.
Or on behalf of Pittsfield Township.
Good morning, Your Honor. Alexandria Taylor here on behalf of Deja Ulmer, who is present to my right. Please state your name for the record.
Deja Ulmer.
All right. What are you doing?
Your Honor, my client is prepared to plead guilty to the amended plea of operating while visibly impaired.
That's correct, Your Honor. So I move that count 2, operating while visibly impaired. Court accepts that guilty plea and moves to dismiss count 1.
Ever sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Deja Ulmer.
All right. And it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order rehabilitative services as well as community service. Could order your vehicle immobilized, could order you to pay the cost of prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You executed an advice of rights form.
I have it right here, Your Honor.
Oh, okay. All right. Thank you. You signed an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will? And because you believe that you are indeed guilty of this offense?
Yes.
On May 26, 2024, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes.
What'd you have and how much?
Drinking tequila with my friends. I'm not sure the amount.
But you had tequila.
Yeah.
All right. Were you stopped by the police or was there an accident?
Stopped by the police.
All right. Why'd they stop you?
Sleep in my vehicle.
You were asleep in your vehicle. Were you at the intersection?
Mm-hmm. Yes. Yes.
Okay. And so the police arrived?
Yes.
Were you ultimately arrested?
Yes.
And were you taken to the hospital for a blood test?
Yes.
And were the results of that blood test a 0.186?
Yes.
All right. Do you have any reason to dispute those blood test results?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
Your Honor, she's already been assessed and I provided that report to Madam Clerk for the file.
For January 15th, 2025 at 9 a.m.
Your Honor, I'm on a cruise that week. Can we go?
You know what?
I know.
Walk up in here. Walk up in here. Oh, we already did this. Will you be back
Yes, Your Honor.
before I write it? Okay.
I will.
It's January 29th, 2025 at what time? At 1 p.m. All right. And what I will do is we'll make sure that probation, actually, I'll tell you what, you should probably stop down and get your instructions at probation on your way out. And Mr. Allen, can you hand this back to counsel and ask her to provide that to the probation department?
Okay.
That way, I mean, we could do it, but
Thank you, Judge.
we'll do that.
It's alarming the rate at which adults drink and drive. It's like they intentionally want to get themselves and others hurt in the process. Here's Ms. Francis facing charges for driving under the influence.
Morning, Your Honor. Allison Castles, Garen Law Group, on behalf of Jessica Dahl.
Jessica Francis.
Hold on, is this your first time on the case?
This is your.
It is?
Yes,
So Mr. Guerin is actually letting you do things.
I am.
Yeah. Go ahead. What are we doing?
All right. We're here on arraignment. We would waive reading and stand mute.
All right. This is an arraignment.
Yeah.
Defendant having waived from reading standing mute, the court will let her in not guilty plea. And where are we going on this?
We would also ask to set out 3 to 4 weeks for another pretrial to allow Ms. Duff the opportunity to undergo substance abuse evaluation to provide to the prosecutor.
No objection from the people.
No objection, Your Honor.
I'll adjourn this matter then to.
January 22nd.
Will that work for you, counsel?
Yes, Your Honor.
Of course, you have nothing to do, so it's gonna work. January 22nd, 2025 at 9 a.m. as to bond. The alleged BAC in this one.
Your Honor, the BAC is 0.305. So very, very high. There was also a crash, a rear end crash.
All right. Anything you want to say regarding bond counsel?
In addition to the facts stated by Mr. Stiller, this is her first offense. She has no criminal history and has remained sober since the date of this of her arrest. And we would ask for PR bond.
Bond would be set at a personal recognizance, $30,000 bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes, I do.
You also understand there should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes, sir.
I'm concerned in terms of the blood alcohol level here as to whether or not it's particularly entering this for this period in the holidays. I think what I'm going to do is I'm going to order you over to community corrections. I'm going to place you on a scram tether, given the level of alcohol and the time of year that we're at. And I've signed that order. And so it's best that you probably report over there before you leave this campus because they're right across the street. Okay? Anything else?
No, Your Honor.
All right. Thank you. Thank you.
Finally, this case centers on Mr. Nose, addressing his probation violations after repeatedly failing to fulfill court-ordered obligations.
How are you doing, Your Honor?
I'm doing well. Yourself? How much? All right.
How you doing, Your Honor?
I'm doing great. You owe money.
I know. I'm trying to actually I wanna be able to I just finished the job last night and waiting on them to pay me. I want to make a payment today, but I'm thinking I'll pay at least $96 by the end of the month, and then I want to ask you if I could get on a $200 payment plan a month.
So hold on. You're gonna pay 96 by the end of the month.
Yeah. I mean, I don't have it right now. If they pay me, I'll pay you today. I just don't want to tell you that and not do it. Will not be able to do it.
Ms. Valera?
Yes, Your Honor. Mr. Knowles used to be on probation, actually with this case.
Oh, I know.
Okay, and so Mr. Knowles was supposed to be before this court back at the end of November. He appeared, but was late. The court issued a bench warrant. With getting the bench warrant recall done, but he did make a payment of the $200 at the end of November, the day he came in, because he wanted to prove to you that he did make it to the court. He's very nervous about talking to you today.
Is he?
When I spoke with him,
Why is he nervous?
I told him to make sure that he comes up with a payment plan that he can do. Not to tell you something that he couldn't do. So I believe that that's why he's setting for what he's asking that you let him do.
Why is he going to give me 96?
It's the
Why did you just pick 96? He's trying to hold on to the other $4. That's what. Is that what you're doing?
No, it was just the odd amount. It was $8.96.
Oh, the amount you owe.
Yeah.
So that's how you picked that?
Yeah. I mean, yeah. I wanted to give you 200.
I wanted you to get that too.
Yeah, I mean, I literally just finished the job. It's the company I do work for. I mean, sometimes you gotta wait on the payment. So
I know. We're waiting on this one. Should I let him do this? Hold on. What is this stuff? I started a long time ago. I was like 20.
Man, trust me, I know. I can't wait till it's over.
Me either. we are in agreement on a lot of things, Mr. Knowles. All right, look. If I let you pay the 96 by the end of the year, and then 200, you going to be able to do that?
Yes.
You sure? I mean,
I just want to get it over with. Your Honor.
I know you want to get it over with, but you need, and Ms. Valera is right. Tell me something you can do.
I could say 100, but if I get more, of course, I'll pay more.
What can you do, young man? I don't want you to have to run in here all the time saying I couldn't do X because of whatever.
Okay.
What do you think you can do?
150 a month.
Where he picked that? See, this is what I'm talking about.
I don't know. I want to pay you the most I can. But
What?
I feel like 200 is reasonable for me.
If you think you can do that to 200.
Yes.
All right. You think he'll do it? But you're wrong every time. No. All right. Defendant to pay 96 by December 30th. Okay.
Yes, sir.
Then $200 per month beginning in January. Okay. All right. Let's get this done and get it over with.
Sir.
All right. You take care of yourself. Have a good holiday.
You too. Thank you.
Well.